Hello everyone, I'm Yazan Ibrahim, or as some of you might know me, Yazan Abu Ghosh. Today, we're going to dive into a fascinating and essential topic, Fraud Examiner Section 2 Law 2.7, Individual Rights During Examinations. Today's deep dive into the world of individual rights during examinations, whether you're an aspiring fraud investigator, a business owner, or simply curious about how organizations manage their finances, or if you are auditor, this journey will shed light on the often complex systems that drive decision-making. When fraud examiners begin their investigations, they're not just sifting through data or analyzing suspicious activity. They're navigating a dense legal landscape where the rights of individuals and the integrity of the process are paramount. Let's take a deep dive into this intricate world, exploring the critical rights, obligations, and nuances that define investigative procedures. Picture this. You're conducting an investigation in a high-stakes corporate setting, and every move you make, every piece of evidence you collect could one day be scrutinized in a courtroom. The first and most foundational principle of any investigation: operating within the boundaries of the law. This isn't just about following rules, it's about ensuring that the evidence you gather remains admissible and that the rights of all parties, particularly employees, are upheld. A balancing act. Employees' rights and duties. A pivotal area in any investigation is understanding the delicate balance between employees' rights and their duties. Think of this as a chess game, where employers and employees each have specific roles and limitations. On one hand, employees have certain rights that cannot be infringed upon, whether they are protected by national laws or workplace contracts. On the other, they have obligations, such as cooperating reasonably with investigations or preserving evidence when litigation is on the horizon. Take, for example, the concept of duty to cooperate. While employees often need to comply with internal workplace investigations, there's a crucial caveat: the request must be reasonable. Reviewing workplace records like inventory logs, fair game. But demands that invade deeply personal spaces, like searching their home, are neither reasonable nor legal. Now let's talk about the duty to preserve evidence. When litigation seems likely, employees are required to safeguard all potentially relevant information, whether it's emails, documents, or data stored on their work devices. Ignoring this can have serious consequences, such as monetary sanctions or even criminal penalties. Imagine a worker deliberately deleting files they think could expose wrongdoing, disastrous for justice and ultimately for them as well. But wait, there's more to consider here. Employees may have contractual rights, whether explicitly detailed in union agreements or implied through a company's long-standing practices. These contracts can define how far an employer can go during an inquiry. For instance, a handbook might stipulate how an investigation should be conducted, effectively becoming a legal guideline both sides must follow. And then there's the vital issue of whistleblower protections. Employees brave enough to report misconduct. Imagine someone speaking out against massive financial fraud are often safeguarded by anti-retaliation laws. In the US, federal and state protections shield these individuals, while Europe's whistleblower directive ensures similar protections, emphasizing anti-retaliation measures. Intricate layers of privacy rights. Privacy. It's a term that feels increasingly fragile in the digital age, right? Whether you're in the US, Europe, or anywhere else, privacy rights in the workplace are a hotbed of controversy. If you're an employer, you might think, they're using company resources. I have every right to check their emails. True, but only up to a point. In regions like the US or Canada, employee privacy is protected in areas deemed personal, like a locked desk drawer or private messages on a personal device. Employers can reduce expectations of privacy through clear, transparent policies, but even then there's a line they cannot cross. In the European Union, privacy is treated as a fundamental right thanks to comprehensive regulations like GDPR. Employers looking to monitor their employees need to tread carefully, adhering to principles like transparency, proportionality, and legality. For instance, you couldn't justify monitoring every keystroke of an employee simply because you're curious. The surveillance must be necessary and serve a legitimate purpose, like safeguarding trade secrets from leaving the company. One of the most sensitive practices is covert monitoring, tracking someone's actions without their knowledge. Unless it's tied to a specific criminal suspicion, good luck defending that in court. Transparency isn't just a nice to have, it's the law in most places. Employees must be notified that monitoring is taking place up front. And for those thinking about polygraph tests to catch a liar in the act, the US Employee Polygraph Protection Act, EPPA, has you covered. Or rather, it has employees covered. Most private employers cannot require workers to take polygraph tests, and refusing a test can't be grounds for dismissal. There are exceptions, of course. Cases involving substantial economic loss and reasonable suspicion might be an exception, but even then, employers must clear strict legal hurdles. Rights enshrined in criminal law. As the investigation moves deeper, the legal stakes escalate, leading us to criminal law. Here, the rights of individuals take on greater significance, starting with one cornerstone, the right to remain silent. This protection ensures that no one can be forced to incriminate themselves under the threat of judicial action. In common law systems, you might have heard this in the context of Miranda warnings in the US. You have the right to remain silent. Yet this right is nuanced. It applies only to questioning by government authorities, not by private employers. Next comes the right to counsel. While this is critical in criminal proceedings, many might be surprised to learn that during private internal investigations, employees don't have the automatic right to an attorney's presence. A private employer questioning an employee does so without triggering this constitutional protection unless they involve government authorities and blur the line between private action and state intervention. Another foundational right is freedom from unreasonable search and seizure. Talk about a buzzword. You might think of television crime dramas where detectives burst in, waving a search warrant. What's important to note here is that this protection primarily applies to government searches, not private employer actions. However, overstepping boundaries, for example, forcibly accessing an employee's private locker, could lead to significant legal troubles for the employer. To tie it all together, failing to respect these rights, or worse, violating them, could render critical evidence inadmissible in court. Imagine building an airtight case only to have it fall apart because you obtained evidence in a way that breached someone's legal protections. That's the risk fraud examiners face if they aren't diligent. And so we arrive back where we began. Understanding legal rights isn't just a background necessity during fraud investigations. It's the beating heart of the process. Get it right, and you ensure not just justice, but integrity at every step of the way. Ignore it, and the entire investigation risks collapse, leaving valuable truths buried beneath legal missteps. Through careful adherence to these principles, both employers and investigators can navigate their legal responsibilities while maintaining the human dignity and rights of everyone involved, and impact, staying true to the educational goals. The line between personal privacy and governmental authority has long been a terrain of contention. On one hand, there are private parties, individuals, companies, and organizations whose actions often bypass the safeguards individuals expect under the law. On the other, there are government authorities bound by the Constitution to respect these rights, most notably the protection from unreasonable searches and seizures. Imagine the distinction like two roads diverging, each bound by different sets of rules. While private parties can sometimes venture into murkier, unregulated territory, government authorities must respect constitutional boundaries. For instance, if you're working in a private office rather than a government space, the search of your belongings might bypass the need for a legal warrant. However, as soon as government officials step into the picture, the waters grow clearer but stricter. Any intrusion typically requires a warrant grounded in probable cause. And what is probable cause, you may wonder? It's not some vague suspicion, but a solid, evidence-backed belief that a crime has been committed and the accused is involved. When it comes to workplaces specifically, matters become tricky. Yes, you have an expectation of privacy in some cases, such as a locked desk, but workplace policies often make privacy a conditional privilege. Employers might introduce consent clauses tied to your continued employment, making it seem as though unlocking your desk is less about law and more about keeping your job. Such nuances demonstrate how legal principles like privacy adapt to organizational contexts, blending consent with a layer of complexity. This brings us to the larger question: What exactly makes a search reasonable? This term, seemingly straightforward, is evaluated through lenses of context. The courts consider two pillars here: the individual's expectation of privacy and the degree to which a search feels intrusive compared to its necessity. Picture someone rifling through your personal diary versus someone checking your bag at airport security. The intent and setting transform the interpretation of what's reasonable. Of course, exceptions blur the lines further. Some decisions to allow searches without a warrant rely on factors like voluntary consent, which must be entirely free of coercion, or the Plain View Doctrine. The latter is fascinating. It permits the seizure of evidence that an officer stumbles upon in plain sight, but only if their presence itself is lawful. Imagine spotting a glowing treasure chest during a stroll through a public park. Fair game, right? But if someone leads you to it knowingly, suddenly, it's not quite so simple. Courts meticulously examine such encounters for any sign of manipulation or abuse of power. Notably, the balance between individual rights and investigative power becomes even more pronounced when you shift the spotlight to different legal systems. Common law countries act like strict gatekeepers of personal freedom, often requiring detailed warrants backed by probable cause for government actions. Meanwhile, civil law systems take a more relaxed stance, requiring permits in fewer scenarios and with thresholds that seem lighter by comparison. These differences reflect society's broader approaches to liberty, governance, and accountability. Switching focus now to fraud investigations by private investigators, another intricate balancing act. Legal boundaries become the cornerstone of ethical inquiry. Fraud examiners, for instance, can conduct interviews, collect evidence, or review public records, but only if their actions remain lawful, prudent, and grounded in good faith. Cross the line into unauthorized surveillance, and even the best intentions crumble into liability risks or legal hurdles. Trust, integrity, and a commitment to finding factual rather than accusatory conclusions ensure proper adherence to professional standards. The exploration of fraudulent behavior doesn't stop there. Investigators keenly tread the line between uncovering illegal practices and avoiding allegations such as defamation. Here we delve into one of humanity's most powerful tools: words. Defamation, whether written as libel or spoken as slander, is the mischievous villain in many legal dramas. At its heart lies the publication of a false statement that harms reputation, with a ripple effect that sometimes spirals beyond repair. The accused can defend themselves using truth or privileges, such as statements made within the protective aura of legal proceedings. But for the claimant, the damage to reputation, often profoundly personal, is the essence of their fight. Privacy laws, another cornerstone of individual liberty, introduce layers of protection to safeguard personal dignity. In the United States, privacy is often seen as part of broader personal liberties, rights that shield citizens from excessive government intrusion. Across the Atlantic in Europe, privacy takes on the air of universal dignity, an intrinsic right enshrined in frameworks like the European Convention on Human Rights, ECHR. Whether preventing unwarranted intrusions into sensitive matters or stopping invasive disclosures of personal facts, privacy rights compel investigators and organizations alike to tread carefully. In the realm of data privacy, these concerns escalate into the digital sphere, becoming a maze of regulations that bind global organizations. Europe's GDPR is the gold standard here, with principles mandating fairness, transparency, and considerations for the original purpose of data collection. Failure to abide by this robust system invites fines that soar up to 20 million euros or 4% of global turnover, a hefty price for ignoring the sanctity of data rights. Contrastingly, the US, with its fragmented state-dependent laws, juxtaposes Europe's comprehensive protections. Both approaches underscore a truth evident across privacy laws. With great data comes great responsibility. Laws surrounding false imprisonment, malicious prosecution, and emotional distress further enrich our understanding of legal complexities in investigative contexts. Each underscores how easily liberty, reputation, and emotions can come under attack, and the care needed to avoid crossing into areas where liability, ethics, and legality overlap. For example, in cases of false imprisonment, Subtle actions like blocking someone's path during an interview call for careful deliberation to avoid accusations of involuntary detainment. Lastly, the world of cross-border data transfers, often a flashpoint for confusion, requires careful navigation. Organizations exchanging personal data across countries must adhere to mechanisms ensuring data safety, be it using international consent agreements or relying on the EU's adequacy decisions. By keeping these principles at the forefront, investigations remain lawful and respectful of differing regulatory frameworks. Thank you for watching, and as always, continue learning. Stay curious, and we'll see you next video.